we are saying, Mr. Chairman, is that the government and so on simply committed an illegality for the entire period up to this time as we speak. And the government is guilty of not acting properly. And they showed utter contempt for the Privy Council's judgment. And they have now come to this Senate to try to undo what they knew all along they ought to have done. And that is cut off all councillors and aldermen from kind of any future functions after the 18th, and allow the CEOs and the mayors and chairmen to carry out those functions as they are going to do, Mr. Chairman. So what we are suggesting is that this illegality that this government has engaged in is unacceptable, and the opposition will have no part of that arrangement that the government deliberately, calculatedly, and premeditatively executed and allow councillors and aldermen to carry out illegal actions and take decisions when they knew, Mr. Chairman, that the Privy Council judgment was in their possession 3 days before the 18th. On that basis, we are advising that this entire clause be removed.
Senator Vera.
Thank you, Chair. Mr. Chairman, through you, I'd like to ask Senator Mark, just for my own edification, if we were to go along with his proposed amendment to delete Clause 5, what effect would that have on the municipal corporations, and what would be the position regarding the work done in those municipal corporations since December 2022?
Yeah, Mr. Chairman, I'm saying if you look at Clause 3, you'll see where Clause 3 captures the terms of the office of the councillor, right, and aldermen, which expired between this period, I hereby extended until the 18th of May. Thereafter, the offices that are supposed to be alive are the offices that are in the MCA, which is, Mr. President, whenever the offices of aldermen and councillors expire under the law, it is the chairman, the mayors, the deputy mayors, and the administrative staff, inclusive of the CEO and administrative officers, who conduct and execute the duties of the 14 regional corporations. The government, through the Attorney General, has to explain to this Parliament and to the country why did the government not take action to uphold the Privy Council judgment and the law, and why they sat on their laurels for almost 1 week and a half. I remember reading in the newspapers where councillors from the PNM corporations were saying they were conducting business as usual. And the reason why they were doing that is because the Attorney General and the Minister of Local and Rural Development never contacted these people and issued an order. That is what's happening. And they are coming here to get the Parliament
Mr. Chairman, I object.
to deal with an illegal.
No, it's re-debate.
So, okay. So, again, members. There's a simple procedure that we follow, that the mover of the amendment is allowed to indicate why, briefly, as to why he's moving that amendment. Senator Vera has asked a question to which Senator Mark has responded. We have Senator Dunarine who wishes to make an intervention, as well as Senator Lakshmi Dayal. I will ask the AG just to respond at this middle part, and then I will allow Senator Dunarine and Senator Lakshmi Dayal to contribute. Attorney General.
Thank you, Mr. President. My request to intervene is really to ask clarification from Senator Mark, if I may.
Well, I will allow you to do that when everybody has said their piece. It will make it much more efficient, because then you can respond to everybody at one time.
Well, not the clarification I seek to get from Senator Mark, because it's clarification that's only in his knowledge.
Okay. Continue.
Would Senator Mark please advise me, how is it that he has come to the information that tells him that the government was in possession of the judgment 3 days before it was publicly released? Could he please advise me of that?
Senator Mark.
I am not compelled to answer the AG on any matter. I am not compelled to answer you on any matter.
No. All right, so question asked, answer given. Senator Dionarine.
Thank you, Chair. I have a question to Senator Mark, because I myself am seeking clarification. In the event that we accept this proposed amendment by Senator Mark to remove Clause 5, my simple question is, what exactly in this act or in this bill would speak to validating the actions of these aldermen and councillors for the period in which the act is dealing with, December 2nd, 2019 to the 18th of May, 2023.
So that's a similar question asked by Senator Vera, to which Senator Mark did respond. As far as I remember, he spoke to Clause 3 in his opinion, specifically. Go ahead, seek further clarification. Do you need further clarification?
Yes, thank you, Chair. And Clause 3, in my respectful view, speaks to the terms of the office, not necessarily the actions that was done or executed by these councillors and the aldermen. So I am just seeking clarification.
Okay, so I'll allow Senator Lakshmi Dayal before Senator Mark responds to that, and then the Attorney General will close off with his final response to comments made. Senator Lakshmi Dayal.
Yes, thank you, Chair. It is not the terms of the office, as in terms and conditions that's being extended by paragraph 3. It is the terms of office. If your office is extended to the 18th of May, then everything you do is valid. This clause 5 was inserted there because there was an attempt to now rectify what transpired after the 18th of May, when there was no clarification given and certain things were done. And then, even more dangerous, and the issue raised by the opposition and the concern we had was about up until the commencement of this act, meaning that there was need for assent and so on, so that councillors and aldermen may have been able to continue to function, and we may have been validating things that could have happened yesterday, when councillors and aldermen may have been doing things. We are not inside of every corporation. So this entire clause 5, if you were to take off now what the Attorney General is proposing to take off, having been called out on it, and you're taking off and thereafter exercise the functions of councillors and aldermen up to the commencement of this act, then clause 5 would sort of be superfluous, because the office is saved to the 18th of May. With respect to how the knowledge came about the embargo judgment, I just wanted to respond to the Attorney General's concern. If Senator Mark doesn't want, I will. It was made in a comment by Mr. Martin Daly in the media, appearing on the news on the 19th of May, the day after the decision was handed down. He spoke about embargo judgment and questioned why the government did not act when they had knowledge of it prior. So I just want to put that on the record, since the concern was raised.
Okay, Attorney General.
Thank you, Mr. President. Thank you very much. I'll say 3 things, Mr. President. One is to delete the clause in its entirety, as Senator Mark requests, would be a very dangerous state of uncertainty, and I entirely reject the request to delete the clause in its entirety. I do that here, as I did in the other place when precisely the same amendment was sought to be made. The second thing that I say is that I can't speak for what newspaper columnists or other persons speak to the extent that Senator Lakshmi seeks to answer the question that I asked Senator Mark, that is to say, what was his source of information that the government was in possession of the judgment. What I can say is that I had been advised by the attorneys for the state that they had been issued to the attorneys a draft judgment which they were not allowed to disclose to clients, and it had been disclosed to the attorneys for the purpose of the attorneys stating whether there were any grammatic or other corrections to be made to the judgment. And there was a very strict contempt of court embargo. I was advised by the attorneys representing the state that if they even attempted to disclose the judgment to the client, which I represented, or discussed its terms, both the client and the attorneys would be held in contempt of court. So that's why I'm very interested to know how Mr. Senator Mark is seeking to interrogate me about my knowledge of a judgment which his knowledge of is tantamount to being in contempt of the Privy Council.